Hello and welcome to Fin 340 Real Estate. Today we'll be discussing chapters 6 and 8, which really deal with the laws regarding real estate and purchase contracts. So chapter 6 needs to do with dealing why do we have to record titles and deeds, how do we discuss the search of titles and deeds, what is the chain of title, what is an abstract of title, title insurance, the turn system. And then chapter 8 more or less deals with sales contracts. So why do we need to be able to record property ownership? Well, if you never record property ownership, then you don't really know who owns the property. And before we had a recording means, it was basically who lived on the land. So today, there are generally large tracts of lands that are not really inhabited or so-called vacant lands. So if you do not live on the land or have possession of the land, it is difficult to say that you own it, unless we have a method of recording that land ownership. So this is pretty straightforward. Constructive notice is where you have effectively lived on the land, okay? And basically you make notice that everyone should know you own this property because you have lived here on this house for so many years. Now, constructive notice also is a legal doctrine which says that everyone has to physically go and make sure that nobody else owns the land which they're trying to purchase, that there are not conflicting claims to the title, and who exactly actually owns that property. Now, the next notice that is required in a legal doctrine is an inquiry notice, which is a doctrine that specifically states that you are required to go ask questions of people who have claims on the title. So when you're going through a title search at a records office or the clerk of courts, the recording office, they have several different names that they can go under. You might get to a title book and it may say that there are conflicting claims of record. And what you have to do is you have to go to each of these individual conflicting claims of record and you have to ask them explicitly what are their claims on the title, what encumbrances do they have, and do they still have those encumbrances or have they been canceled? And if they have been canceled, then you know exactly who owns the deed. So you have the requirement to inquire. Another example of how this occurs is if you are trying to purchase the property, let's say an apartment unit, and there are renters in that apartment unit, then you have to go to each renter and you have to ask them, for example, do you have the right to buy your property or buy your apartment out, or right of first refusal, which we'll discuss in chapter 8, which says that if I try to buy the property, then the renter has the right to try and buy it from the original landlord to begin with. So you have to make inquiry notices of these renters to make sure that they don't have these right of first refusals or lease to buy options because those will not be recorded on the deed. And so the law says you, the purchaser, or the individual who is inquiring of the deed has to go and ask these questions. Now, this is typically done by a lawyer, which is why we're covering these in brief. We're not really doing them in detail. You specifically, as a real estate individual, will generally not deal with constructive notice and inquiry notice and trying to figure out who actually makes party to the deed. That's going to be handled by a lawyer in most cases. Now, actual notice is where you have been given factual evidence that the property has been possessed by the actual owner of the deed. They physically live there. Okay, so actual notice is pretty concrete. So then there's no way to break actual notice. Compared to inquiry notice, where you have to ask questions about do you continuously hold claims on the deed, actual notice is a point-in-fact thing. This individual has name on the deed and they are living on the property. Then we know that they probably have fee simple ownership of that property. Okay. Now, several recording acts have made it so that you have to now register your property in a general database method system, so that everyone now knows publicly who owns what land. And we use the track and plat books to do this. So a land granting indexing system is done where they go through, and as we discussed before, how you identify parcels of land. Along with those identifications are deed titles, which tell us exactly, given this parcel of land, who owns the deed to that land at the current time. And you are required to record ownership of that land once you purchase it. And in fact, it's done pretty much automatically. You have to pay fees when you do the transfer of deed. at the recording office, and they immediately record the new ownership of the deed, et cetera there. So the Mortgage Electronic Registration System, or the MERS, is a very large organization of the 20 largest real estate organizations and insurance companies in the United States, which got together and figured out that they could do the booking system better than most of the clerk of courts and the registration offices of most counties, and keep these records in a much more detailed way. And they can keep it electronic. So now it's not necessarily that these records are sitting in the clerk's office in a plat book that you have to go find the deed book, go find the page, and figure out where this tract of land is. It's all electronically recorded. And this electronic recording system exists not just for real estate, it exists for cars and boats and other sorts of real property interest and chattel property. And they all are co-signed by the federal e-sign system. For example, if you've ever signed your taxes, you've dealt with the federal e-sign system, which requires that you can sign them electronically, but you have to go through this additional website that's not exactly part of the IRS. Well, those are all part of the same MERS system, and they have to do with mortgage transfer as well. So mortgage loans are transferred through the MERS system. The deeds are transferred through the MERS system. And all of these are recorded immediately, and it gives us a very easy way of tracking who owns what property, is it mortgaged, are there claims and encumbrances against that property. It makes it very easy to deal with today. Okay? So the reason we do this mortgage interest system is we want to get rid of unrecorded interests. If somebody has an unrecorded interest, it's a bit of a problem. And in most states, unrecorded interests are limited to a certain period of time for their claiming statute of limitations. But unrecorded interest can make a problem when you're trying to transfer the deed title. If somebody has a claim to the property and you transfer the deed title to somebody else and that individual didn't actually own the property, so person A has the deed, but they don't actually own that property in real fact. They transfer the deed to person B under warranty, saying that they believe that they own the title, when in the real case they don't actually own the title. Person B purchases the property by giving consideration or money to person A. Now, person B believes they have fee simple rights to the property, when in fact person C was the original owner of the property. Person A had no right to transfer the property, and so person C still legally owns the property. Person A, again, could not have done the transfer, so B could not own it. Okay? That's a problem with title ownership conflicts, and that's why we have to have these electronic recording systems now to make things very clear and simple as to who owns the property today and what encumbrances exist, so that we don't have problems with unrecorded interest in trying to figure out who actually owns the property. So, what do you have to have in order to make sure that your deed title transfer is properly recorded? Okay? So you need a witness. That's the big one. If you're not going to do a notary public or do it in front of a judge, you need witnesses in states that allow witnesses. And generally, you're going to need not just one, but two. And the way that works is you've got a signer for the seller and the buyer. You generally need a witness for both the seller and the buyer who counter-witness that the buyer signed and counter-witness that the seller also signed. Okay? So basically, they're not interested in either party if they're counterparties to each other as well. Those witnesses have to be willing to testify in court, so it's a pretty big thing. If you're going to ask somebody to witness for you, they had better be willing to go to court and profess that they did, in fact, see you sign and that you were of good health and good mind in making that decision. Acknowledgments are done by notary publics, so acknowledging that, again, it's like a witness, but a notary public is effectively the job that is dealing with being a witness. Okay. You come in, you sign in person, you provide identification that you are, in fact, who you say you are, and the notary public stamps their seal that says, I, and the notary of the state who is licensed to make this decision, agree that you are who you say you are, and you signed this document. Many of us have dealt with notary publics before. It's generally not complicated. The problem is you actually need to get a notary public, and that can be a bit of a headache. Predominantly, if you're going to be running a large real estate enterprise, the fees alone for notary publics just to get documents signed can be egregious. So a lot of times what happens is they will hire a notary public within the firm themselves, which can actually get you into trouble because the notary public should be, or actually has to be, what they say is arm's length transactions away, which means that they cannot sign for acknowledgments which are beneficial to the company in which they work. They have a conflict of interest. Okay, but many companies still to this day will hire a notary public in order to lower the costs associated with doing real estate work for that purpose. So as far as title searching in the tract of land, you can go to any sort of records office for the county government usually. In some states there are not many counties, so you might have a state holder record, but they're generally held at the county level. And you go into the recorder's office and you can go in and ask free of charge, just say, I would like to look at the deed books. As long as you know where the tract of land is, and we talked about the township marking system and the southwest-southeast method, we can, if you look back at chapters 1 and 2, you can review that if you would like. If you can find the tract of land that you are on, then you can figure out where the property is in the deed book. And then you can look up the index of the grantor and the grantee, and you can then begin what is called title search. Title search is a complicated bit of work where you have to go through and look through who had the title at all points in time since the original deed was granted from the state to the original first purchaser. Okay? So this is very important to do because we need to know who has owned the property. Did they legally give up the right to ownership of that property in a transfer of deed title? Okay? Or do they still own that property and the transfer of deed title through the line was done illegally or inappropriately? Okay? Or are there any encumbrances? Perhaps somebody originally owned the title and they didn't pay property taxes, and the state seized the property, but during the time in which the seizure was occurring, the individual sold the property to Mr. Smith. Mr. Smith may think that he has full claim to the deed and fee simple rights, but in fact the state has taken possession of the property and attempted to sell it so that they could recuperate their property taxes. So Mr. Smith does not actually own the title of the property. Well, the title search process would figure that out. So it's very important to do that so that Mr. Smith would figure out, well, he doesn't actually own it. So in the title search, you will do generally two methods, abstract of title or chain of title. And a lawyer is going to do this, and many times the lawyer's sole job may be to do this, but in rural areas it may just be a part-time job. So the idea here, they're going to sit there and go from the beginning when the property was originally granted from the state or from the governing body, because some of these areas predated statehood in the United States, to the original purchaser of the land. And they're going to continue through with the deed right and who was it sold to. So in this example here, we have the Arapaho Nation, and then that was sold to the Niels Olson, okay, under warranty deed. And that was recorded in 1918. 80 acres of area without the mineral rights. So remember, we talked about those subsurface rights. And then a few months later, they sell it again with warranty deed to Fermi. Okay, so basically they explain who Mary Fermi is there, and they record it there. Okay, again, the same 80 acres. All right, with no mineral rights. So we're tracking the ownership of this property of land, this block of land here. And they will go through all of the ownership up through 2019. And provided there are no gaps in the chain of title, then we know that the title probably has the correct ownership today. Nobody has an encumbrance on it. And it is what is called a marketable title. Okay. A marketable title is a title which is free from the assumption that anybody else has claim to that title and we could sell it or sell the property easily without any unrecorded claims or interests coming up. Okay, that is called a marketable title. But chain of title searches is very difficult to do and very costly to do. So in general, we're not going to see those. Instead, what you're going to see is an abstract of title. which is basically a very short document that just lists who owns the property or has had prior claims to the property at any given point in time, and it's just going to all be written together. The abstract of title doesn't try and figure out who owns the property today. It does not care. All it tries to say is, these are the individuals who have owned the property in the past, or who have had encumbrances, mortgages, claims upon their property in the past, who may currently have claims to the property at the current time. Again, it does not try and figure out who currently has right to the property or who previously had right to the property and in what order. It doesn't care. It just says, these are the ones who had it before, and we're going to list them all here as a snapshot. Now, obviously, chain of title has more information and is a stronger method of analysis, but abstract of title is far cheaper to do, and lawyers can easily offer abstract analysis and their own warranties as to the validity of who owns the property. Okay? If you cannot figure out through title search who owns the property through the lawyer, you can initiate what is called a quiet title suit. During a quiet title suit, the judge, who is going to be hearing the suit, will try and figure out who has any prior claims to the property, and do they still have those claims to the property. If they figure out that there are conflicting claims to the property, the judge may order a judgment of cancellation on one of those claims to simplify ownership of the property and be able to make the deed marketable so that it can be sold. So they can figure out, well, only one person now owns it because we canceled the right of this other person. Okay? Now, how to cancel the rights of the other person? Either the judge can make that decision under the quiet title suit, or you can try and pay off the rights or claims to the deed itself. Or you can try and just say to the person, well, this was 50 years ago, do you still care? And if they don't care, maybe they will just cancel it out of goodwill. Probably not going to happen if the individual is smart. But you can very easily sue under quiet title claim to have other claims on the title removed so that you can simplify the deed process and make it marketable. So, due to the fact that sometimes people would transfer titles which they did not actually own, then we have a problem where, well, if you buy that and you put all your money into it and you don't actually end up owning that property because somebody had owned it before and it wasn't the person you bought it from, well, you would be happy to have insurance, wouldn't you? So we have title insurance, which really originally sprang out of lawyers wanting to be protected from their own mistakes in attesting that the title was owned by one individual or not the other. We now have this pretty common in transfer of almost all titles. So the idea being here that we want to make sure that the title being transferred is warranted by one individual and we know who that individual is, and it's typically the seller. Okay? And if it's not that seller, then we have insurance which would pay for the loss of the value of the property that the buyer incurred. Okay? The premiums on these policies are not terribly large today. Because of our electronic recording system is pretty robust, then we don't have tons and tons of errors. And it happens to be, again, as we discussed before, the insurance company who is keeping all of the documentation there to make sure that they're able to figure out when there are going to be any errors. And this robust documentation system is lowering the likelihood that there are errors to begin with. So you can see that the insurance companies are helping to reduce their own premiums, but also reduce claims on those premiums. Now, the other case where, and this is the big one, who really wants the insurance? It's not really the buyer, it's usually the bank who's going to require it if you're going to get a mortgage on the property. Because they obviously do not want to mortgage a property whose the title could not have been transferred to. Effectively, they give money to the seller who could then just disappear. And the buyer doesn't actually own the property, therefore they cannot take possession of the property if the buyer defaults on the loan. So they really would prefer to have title insurance in order to protect against such losses, and that type of insurance is called a loan policy. So that is an insurance contract to the bank who is offering the mortgage, not an insurance contract to the buyer of the property. That is a title commitment policy. Okay? Now, claims for losses are typically significant if they exist, but the title insurance company is going to usually figure out what went wrong and be able to countersue or counterclaim against the wronging party if they can find them. And again, these companies are very large and pretty good at their job. So the policies have come down because the claim losses have also come down significantly. The Torrens system was a system designed by Sir Torrens because he figured out that, well, shipping logs, basically figuring out who owns which ships in Britain, was a much more efficient method of recording ownership of effectively real property that moved nonetheless, while the land system was undergoing the deed book system, which is very inefficient. And so he proposed the land system could be based on the ship system. And that had been used in Britain and in some places in the United States, but it was not widely adopted in others. The Torrens system requires immediately that you do a chain of title search in order to make sure that who owned the property is correct, and that chain of title search is more expensive than the abstract search. So in many places in the United States, they didn't want to use the Torrens system because it's simply much more expensive. It is very efficient, but it was much more expensive up front. So in the short term, it wasn't profitable for them to use it, and they maintained the standard registration system. However, today, it can be the case that you will have some houses on the same street which are registered under the standard registration system, and some which are registered under the Torrens system. And that can be complicated because if you're trying to buy many different houses in a property, let's say you wanted to buy out several parcels of land so you could consolidate them and build an apartment complex. And some are registered under the standard system and some are registered under the Torrens system. That makes things a little bit more complicated. But usually it has to do with certain cities and only certain areas of certain states. Except for Hawaii, all of the properties in Hawaii are under the Torrens system. Okay. Sales contracts in Chapter 8 here. I should have put a title slide for Chapter 8 so we were moving on. Sales contracts are just simply agreements which notify a buyer and seller have come to an agreement to transfer the title of a property at a certain price on a certain date, and that the seller will take possession of that property provided the money is given. Okay? That's it. They follow all sorts of sales contracts that you see in general transfer of property. When you buy things from a grocery store, you actually have an implicit sales contract. We don't write a legal one, but there's an implicit one. You are giving money to the grocer. They are giving you goods, which is the groceries. They have given you consideration, the groceries. You have given them consideration, the money. Consideration means exchange of goods or value. Okay? And you have an agreed upon time for the exchange, and that's immediately, effectively. And because that exchange occurs, the contract is settled. Okay. Now, if, for example, in Kroger, you can pay for things and you can have them picked up later. If you never pick up the goods, technically you can reject payment for those goods, and Kroger will have to restock them. Now, they may have in their agreement for use of picking up goods later, if you don't pay for them and you don't come pick them up, they may charge you a fee, okay? And because you didn't perform on your contract. Now, that's just a separate implicit clause that exists there. And you probably agreed to it when you did the acknowledgments and terms and conditions if you signed up for the pick up later feature that they have at Kroger. Okay, but that's an example of where you have a sales contract in everyday life. You've also got it in real estate and cars, et cetera, et cetera. In the case of real estate, we have consideration, which is delivery of the deed or the title property that you're purchasing, which is to take possession. So when we say delivery with respect to real estate, we really mean taking possession, i.e. move in, obtain access to the property, and go there. Okay. That is consideration from the seller to the buyer. From the buyer to the seller, consideration is in the form of money, okay? Or likewise goods. So if you could technically swap houses if you wanted. Probably not a very good method of doing things, but you can legally do that. You can do in-kind transactions. But you've still got to exchange something of value. But again, traditionally, this is money. And the buyer usually in today's United States market will obtain the money from a mortgage at a bank. So the mortgage will handle process of all the money because you usually don't have enough cash on hand to make these transactions. And because there's a bank involved, there's a seller involved, there's a buyer involved, and it's usually a very high price ticket item, these go through what is called escrow accounts. These are legal accounts watched over by lawyers and bankers to make sure that basically everyone is going to do what they say and nobody is going to get hoodwinked in this transaction. That's all an escrow account is. And during the entire time that the sales contract is coming to close, money may sit in the escrow account, money may flow out of the escrow account to meet expenses, and at the end of the day, what's left in the escrow account will be returned to either parties in proportion to the amount that they are owed. Okay? So it's really this just black box account that tries to handle everything during the period of time at which consideration is being exchanged. Okay? Now, in your book, you have an example of a sales contract, and we want to go over some of the major points of the sales contract paragraphs. So one of the key points in the contract that we need to talk about is earnest money deposit. Okay? This is an early provision of money given to the seller, typically put in the escrow account, that says we are now in good faith negotiations. Good faith means that I plan to close the deal. And I'm going to give you a little bit of money to make sure that you agree that we have begun to negotiate and that I have some money to show you I'm capable of doing this. Okay? Those of you who are a little bit confused about how this works, if you know marriage, the giving of an engagement ring is the example of earnest money deposit. Okay? It means that typically the male, if you want to get back to tradition, okay, the male has enough money to pay for the wife. And that's why the engagement ring has a diamond, whereas the wedding ring is usually quite plain, just a gold ring. Okay, so the engagement ring comes with a diamond. That is an earnest money deposit. I have enough money to purchase this asset. Now that's pretty crude in the modern sense, but that's historically how it worked. Okay, so earnest money deposit is usually necessary to keep somebody else from entering into a sales contract with the seller. That's why we do it. If you provide an earnest money deposit, the negotiation has begun and nobody else can enter into a sales contract negotiation with the seller, so long as the earnest money deposit exists and for a specified period of time. And that's very important because the negotiations can take a long time. If somebody gets to the table and negotiates faster than you while you are trying to work on your deal, then you may lose the deal. So the earnest money deposit makes sure that nobody else can do that. The deed and condition of title in paragraph 7 is usually there to stipulate how are we transferring the deed, and this will almost always say with warranty. Okay? We're transferring the deed with warranty, which means we believe that everything we own the title and we have fee simple rights and we're able to transfer this title. Okay? It does not mean that it is without possibility that everything is in order. Okay? It could be that there's something wrong. That's what warranty means. Okay? But it's basically going to say with warranty and allows us to transfer it, but we're going to need to get insurance on that in order to make sure it's the case. Okay. Condition of the title also will be, well, we know that it is free from other claims, or here are the encumbrances. It will list them that exist upon this deed that need to be settled if you're going to purchase it, or that will just simply transfer with the purchase of the deed. Okay. Paragraph 8 will list who is responsible for closing costs and who is responsible for dealing with the closing and who is the escrow agent. So this may be either of lawyers for the party, the seller or the buyer. It could be the bank. It could be an escrow service. Okay, but it must list who are the escrow agents and who is going to deal with the actual transferring consideration of property. Then you will have several paragraphs which deal with sundry requests. For example, termite inspection is listed in your book. So the requirement that for this to go through, the seller must incur a termite inspection in order to make sure that their termites are not eating at the foundation of the property. The buyer doesn't want to incur this cost because if termites were to be found, then they would have provided a free service to the seller because obviously you don't want to buy property that has termites in it. That would be a bad investment. So the deal has been struck that the seller will get a termite inspection and will furnish a documentation of that inspection, clean and clear of termites, to the buyer upon transfer of the property. Okay, so these are sundry requests, and they can have various ones there. You can have foundation inspection, you can have mold inspection, The various reasons that you might have things inspected, fairly important. Lead paint inspections or warranty that lead paint has not been used is pretty common. And asbestos is another one that you will often see in older homes. Okay. Possession, and I am paragraph 13, it tells us when possession will occur, and this typically is the date of closing. Okay, if we would like to say possession occurs earlier or possession occurs later than the date of closing of the contract, then that would be stipulated in this paragraph. It tells us you may take possession later. I have just recently read a lease agreement for a college student that's going to school in Ohio State that said that they are going to take possession of the property on the 15th of August. But the lease contract begins on August 1st. Okay, so understand what that says. The lease contract begins August 1st, possession occurs August 15th. That means that this student was entering into a lease agreement but could not move into the property for 2 weeks. And then another little clause built in there said, well, you have to pay the full amount of rent on the 15th. You don't have to pay on the 1st, but you have to pay on the 15th. But you do not prorate that rent, you pay the full month. So effectively, this landlord was trying to stiff this college student, probably every other college student who was trying to rent from them, for 2 weeks of rent by saying, you must pay the full rent, but you can't move in yet. Okay? So that's where possession can get dicey, and you need to be very careful about reading possession clauses in rental lease agreements and in sales contracts, because you may end up forking over money by not being able to rightfully enter the property. Okay? Time limits. Basically, paragraph 21 there. They will say, we are agreeing to this deal, and you have 2 weeks to get back to us as to whether you would like to strike this deal with us. You would assign and return the contract. The reason time limits are placed there is because we cannot just offer deals and then hope that the person gets back to us in a month. They may get back to us in a year. And if you don't put the time limits in the paragraph, if you don't say anything about time limits at all, then they have all legal right to wait as long as they would like. And suppose 10 years occurs and they say, well, we would like to activate the sales contract and you are no longer interested. They could sue you for performance. Okay, well, 10 years is a bit long. Well, let's say a year goes by and you are not interested. You moved on to other properties because they simply ghosted you. They stopped talking to you. And they say, well, look, you agreed to this sales contract. I have your signature. There are no time limits in this contract. We are suing you to perform, which means that they are forcing you to buy the property at the agreed upon price. And you will probably lose in court. So it is very important when you're going to make a deal or make an offer that time limits are in the offer. Okay? And it needs to have the following phrase, time is of the essence, which seems very archaic and very strange to say. But what it means legally is we're not going to give you an extension. Okay? If we said 2 weeks, you have 2 weeks to get back to us. At the end of 14 days, this deal is done. It closes, it cancels automatically. Okay? Time is of the essence. So it needs to say that, or the deal could go on for 15, 16 days. Okay? So it's very important that you have the correct language in the contract with respect to time limits and that you adhere to the time limits yourself. You don't want to go to the 15th day and then ask for reprieve. It's just not going to look good. Okay? Now, if the buyer and the seller come to an offer, and let's say that the buyer makes an offer and the seller has a problem with even the slightest bit of a contract, then the entire offer is invalid. It's rejected. Okay. Now, usually what happens is if it's something that's negotiable, the seller will just take the contract, they'll change whatever they would like to change, and they'll send it back to you. And that is a counter offer. And then perhaps you may agree or disagree with that change, and you may send it back to them as a counter offer. And this goes back and forth. So even though it is said that the entire offer is rejected and not in force, that is just a legal nicety. A counter offer is naturally automatically created, okay? So long as they send something back. Now, if they simply say, this is the 5th time we've counter offered, change is non-negotiable, okay? well, then you can't make any changes. It's a yes or no situation then. If you say no, the deal doesn't occur. The deal is off. There's no more negotiation to have. They don't want to continue down that process. If you say yes, then you accept the offer as is. Okay? So be very careful about counteroffers and rejections, because if you just simply say no, then they don't have to negotiate with you. They can just end the deal immediately. In some states where it is legal to use a binder, many real estate agents will have a quick sale contract which says that you, the buyer, and the seller have come to an agreement for a specific price to buy this property. And this is called a binder. It doesn't list anything else. There are no other writers or clauses to consider here. Just you agree to buy this property. Is it a legally enforceable contract? Well, if consideration can be done and there is good faith, and if you provided earnest money, for example, yes, it can be a legally enforceable contract. Even though nothing else is stipulated in the binder's contract, it can be enforceable for performance. Okay? So you can be asked to perform on the contract. Now, performance does not mean that you have to buy the property just because you said you were interested in buying the property. That's not what performance means. If you cannot come to an agreement on the contract, for example, you couldn't come to an agreement over who was going to incur the termite costs, well, then you have a right to get out of the binder. Okay? You can agree, you can say, I'm not going to buy it because we can't come to an agreement on the termite expense. All right? So you would have a way to get out of the binder. It does not necessarily mean you must purchase it. It just means you probably should purchase it. And if there's no reasonable or legitimate reason for you to back out, you may be forced to purchase it. It becomes a court matter then. Okay? Now, binders are nice because they allow for you to lock in the agreement while the deal is being drafted. It takes a while for sales contracts to be written up. So in that 3 to 4 days of time, you don't want somebody else coming in, as I said before, and buying the property out from under you. So the binder allows you to basically shake hands with the seller and say, we're going to purchase this property. Just wait for us to get the contract drawn up so we can talk about the specifics. Okay? You can also consider this a back of the envelope deal or a handshake deal. They are legally enforceable. Okay? Again, what is not listed in the binder is what makes them dangerous. Okay? Also makes them weak. All right? Very, very considerate of what's not in the binder and what should be in a formal sales contract. Now, a letter of intent is just simply a letter that says we are interested in buying this property. Okay? We are interested in negotiating on the purchase of this property or the sale of this property. It does not create any legally enforceable interest. There is no obligation created by a letter of intent. Okay? It just says we are now open to negotiation, and this is typically used in business-to-business contracts, not retail residential purchases, but purchases of large tracts of land or commercial property such as malls, okay, or industrial property. A letter of intent usually goes between the lawyers that says we are open to negotiation, and please keep lines of communication open to that effect. Okay, before we move on to mortgages, which is the next chapter, installment contracts are a very convenient and common way of selling property without going through mortgaging in a bank. Okay, so basically the seller says, I will sell to you the property if you provide me with a substantial down payment and then make monthly payments on the property thereafter. During such time, you, the buyer, can take possession of the property. You can enter the property and act as if you're the owner, and yet you don't have the deed. The seller still has the deed. Once you have made all of the payments on the property, then the seller will provide you the deed. Okay? Now, installment contracts became very popular after there was a spike in interest rates. Okay? It became easier for large land sellers to use their fixed funding methods, basically mortgage the property themselves, take the payment, the monthly payment from the buyer, and just pay off the mortgage that they had financed because they're pretty large. So when the individual small people buyers couldn't get mortgages, this became a very common way of getting around that problem. All right, a lease to buy or lease or option for a lease to buy, okay, allows you to lease a property and then buy that property during a specific period of time at a specific price. Okay? You can rent, and then if you really like it, you can buy it. I find this to be a very powerful method of determining whether you actually like the property. One of the biggest problems with real estate is buying a piece of property which you do not like. Buyer's remorse. Okay? You think you like it, it looks nice from the outside, but once you get into it, it's too small, the lighting isn't right, maybe there's not enough bathrooms for your household, maybe you just end up having a kid, okay? And now you need an extra bedroom. Well, if you had been leasing, then you could be easily able to make a determination as to whether the property fit you, and then you could buy it if you wanted, okay? If you had bought it outright, well, then now you've got to sell the property and buy a new one, which is infinitely more difficult. Okay? So lease with the option to buy is fairly powerful. Okay? And most landlords are somewhat happy to deal with it, provided that the rental income derived from the property is not more than the value of the sell right. Okay? So if they can get more money by renting the property to people than they could by selling it to you, they're not going to sell it to you. So they will not put a lease with the option to buy in the property or the deed. Okay. Another item that is often included in lease agreements, and you can usually negotiate for this, but you should probably have sufficient means to do it if you would like it in there, which is the right of first refusal. Basically, the landlord doesn't really care who buys the property, so long as somebody buys the property. So if you negotiate a right of first refusal, if some third party comes up to the landlord and says, we would like to buy this property for this house that you are currently renting for, let's say, $400,000. You have the right, if you have right of first refusal in your lease, to say to the landlord, no, I'm going to buy it from you for $400,000. Again, the landlord doesn't care. He's getting $400,000 either way. He doesn't really give a shit about who is actually purchasing the property. Okay? But it gives you the right to veto who will buy the property. And this can be particularly interesting for the leasee because they don't necessarily want to have an up-in-the-air landlord. Okay? They're going from landlord A to landlord B. Well, landlord A may be a great individual, very easy to get along with, responds well to maintenance requests, and is not very stingy. Whereas the new landlord B could be quite stingy, not respond to maintenance requests, etc. The soft key skills that result from rental agreements are up in the air. Okay? And there is no law that says that the leasee has any right to decide who the landlord is or how they act. So the right of first refusal allows for the leasee to protect themselves from a change in the landlord. But again, you need to have sufficient means to purchase the property or the right to first refusal becomes useless. Okay? All right, that is the end of these two chapters. Again, you have your exam opening up on Friday. The last two chapters will also be released Friday morning, and then you can review them prior to your exam. The majority of material from the exam will relate to the upcoming chapter with mortgages, and then the prior few chapters, not really including 6 and 8. 6 and 8 predominantly deal with contract obligations. It's just things you need to be aware of, but they're not things that I'm going to drill you with respect to questions. Okay, until next time.